Hello,
Hello,
good
ma'am.
evening,
Good
everyone.
evening.
Welcome to the World Cybersecurity Forum session on practical aspects of international mooting. My name is Megha Ahuja, and I am a practicing advocate at the Supreme Court of India and also the program head of Department of Cyber Affairs at World Cybersecurity Forum. And I will be serving as your moderator today. You will be hearing a presentation from Dr. Bhavna Batra on this very timely subject. But before we get started, I wanted to take a few minutes of your time. The session has been organized by World Cybersecurity Forum as a part of our International Cyber Mentorship Program 2021. As you all know, World Cybersecurity Forum is a globally prestigious cyber consultancy and web community that tends to create awareness in regard to various internet issues and goes as a wellspring of techno-legal information for professionals, students, teenagers, and middle-aged civilians around the globe. As a dedicated cybersecurity platform, World Cybersecurity Forum has been catering unbiased information to professionals on the countless security challenges that they come across every day. At today's session, we will be discussing the practical aspects of international mooting. Mooting definitely helps law students to boost morale and improve their research and public speaking skills. In the World Cybersecurity Forum's International Cyber Mentorship Program, to understand the importance of mooting at international level, we have invited Dr. Bhavna Batra. Dr. Bhavna Batra, who is the speaker, is the assistant professor of law at Amity University, Noida. She is an academician with an enriched teaching experience of more than 15 years. She did her BA English honors from Miranda House College, Delhi University, then LLB from Faculty of Law, University of Delhi, and her LLM from Jamia Millia Islamia University. She started her teaching career in 2005, and in 2012 she joined Amity Law School, Noida. She is also serving as Vice President, Amity Law Foundation, and Member Secretary, Amity Judicial Academy. She is also an energizing and dynamic convener of Moot Court Society. Currently, she is serving as the National Administrator from India in JSF International Moot Court Competition. Along with it, she is a potent member for hosting different seminars and conferences and cementing international relationships for teaching and student legal fraternity. I myself is pretty excited for this one because I have also learned techniques of mooting from ma'am in my college days, and she is very helpful to all the students. Now, without wasting any time, I would like to call Dr. Bhavna Batra ma'am to take the session forward.
Thank you, Megha, for this wonderful introduction, and a very good evening to the wonderful audience who are a part of this session today. I assure that in this journey of my session, nobody is going to get bored and you will learn a lot. My session is not at all a session which I've picked up from the textbooks. My session is especially a session which unfolds the academic odyssey of mooting. So, dear students, dear friend, at the outset, I would like to congratulate each one of you for being the part of the most wonderful forum, that's World Cyber Security Forum. And I will also take privilege of thanking the organizing team for wonderfully engaging each one of you as mentees and all of us as mentors to cherish this journey. Students, audience, my dear friends, we all know that legal profession is a challenging profession. When I say challenging, it involves that profession is also demanding. We all know ultimately we need jobs. So when we are looking for a good job, the graduates, the law students also need to prove the industry that they are ready for the industry. That zeal to be ready is actually the zeal that comes from within. Students, do you feel that you need to think like a lawyer, act like a lawyer, work like a lawyer, and react like a lawyer? And quote under quote, you can also think that you need to work under pressure. Mooting, simply known as Moot Courts, Moot Court Competitions, co-curricular activity in a law school reflects your competitive, individualistic, and adversarial perspectives of the judicial side of law. Many questions come in our mind. Mooting. Why to take extra stress? Why do I moot? What is a moot? What is a moot problem? Will it enrich my CV? Will I gain something? Do I have that confidence? Can I work in a team? Can I do good research? Am I competent enough? What mooting will give me? Oh my God, so many questions. Yes, so many questions. And when you have questions, your mind starts working. And this is what we are here for, channelizing everything together. So I would just be beginning my session with my presentation, which is a very practical presentation. And let us see how I unfold the journey of the moots. So if the organizers can let me know, is my PPT visible?
Yes, ma'am, it is. Yes, ma'am, it is visible.
All right, thank you. So the title that I have taken for my program for this session is Moot Courts, Clinical and Experiential Aspects of Legal Education. And I will be focusing on certain basic aspects. And finally, I'll be coming to international mooting with a practical insight. So, clinical and experiential aspect. The term looks flowery, but there is a lot of meaning hidden in these two words. You go to a clinic. Oh my God, why? Because you want to see how a theory can culminate into a practice. So students, dear friends, Bear Acts, statutes, constitution, convention, treaties, charters, are we there only for these? No. We read these and then we have to see and visualize whether we can bring these into practice. So that means legal education is now no more only books, Bear Acts, statutes, constitution, precedents, judgments, case laws. It is something beyond, an edge beyond books. So we will make legal education clinical. Let's do experiments in law. Let's see whether we toss a coin, either it's heads or tails. So we learn through clinical mode by an experience. Are we prepared to face the real world? Who will give us the answer? We will give the answer to ourselves. So that is experiential learning. And how do we promote or inculcate experiential learning? You have a chance. How? Moots. Moot courts are actually a blend of oral skills, research proficiency. So blend them. Bring a jar, put your oral skills, put your research skills, turn on the button, start blending them. Now a question. I can't speak well, I'm scared. I have no confidence to speak fluently. What should I do? Should I not moot then? Why not? Be a researcher. I can research well, yes. I am a bookworm. I can read between the lines. I can interpret. Then why I can't moot? Let me be a researcher. and I'm going to score well in the researcher test and make my team up. Let I not be a good orator, but yes, I can learn the art of advocacy. Okay, so blending works. I am not a good researcher. Oh, you burn the midnight oil. I have an art of argumentation. I can debate. I can rotate. I can convince. I can persuade. But research, no, 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 no. Why can't I moot? I will moot. So a blend again. Blend of oral skills and research proficiency. What else do we need? In a law profession, either we are a good orator or a good researcher. So that's a tip. Don't think you can't speak well. Don't think you can't research well. Team up and you can moot. So, if you can speak well, you can influence and you can change lives. So, yes, through my art of speaking, I will convince the judges and persuade them to listen to me, and my speaking will bring change. I can do my research well. Research is to what everybody else has seen and to think what nobody else has thought. So, in my case, when I present my argument before the court, I'm going to bring something which nobody knows. But through my research, what you can't think, I have brought before you. So, dear friends, mooting is again, I quote unquote, a blend of oral skills and research skills. And that friendship, that bond is absolutely unique. Now, when I say, what is mooting? A very simple way to define mooting is stimulations. You can't sit like this. What is happening? Nothing. So when you stimulate, rotate, think, act, perform, speak, target, hit, you can moot. So mooting is a stimulation of a court proceedings where a student team, please remember I'm focusing on the word team. So you're not alone. The battle is to be fought by the team. And you are presented with a legal problem and you have to argue. And we all argue. We know how to argue. It's just that we have to argue candidly and properly. So, dear students, the closest experience that a student can have while he is in a university is to appear in a fictitious court. And who is giving you that experience to appear? Moot courts. Now, epicenter, a turbulence, earthquake. How do you measure the scale of that earthquake through a Richter scale? Through the focal point that is called the epicenter. So, my dear students, epicenter of any moot court, you just need 3 points to focus on. The art of persuasion, candid, flawless presentation, and the craft. So these two words, art and craft, we all remember when we were in school, in colleges. We used to have an art and craft period. And we used to think, oh, let us relax for some time. And we can use our imagination and bring a change in the world. So the art and craft of persuasion and argument is what a moot court is all about. So you have the art to speak, to persuade, present before a bench of people. They are also humans, just like you. You do more research in a moot court than your judges. You get a lot of time to prepare for that moot, and you present before them your case. That's called the craft of argument. So my dear audience, please remember art and craft, and we all love to do art and craft. My aspiration comes now. Why do I moot? The aspiration to moot, that desire, willingness, spirit. The very purpose of a moot court is to urge, that instinct, stimulation again. Urge the student to think like a lawyer. So when you think like a lawyer, you think out of box. And then you apply legal principles and argue legal fiction within the realm of law. So what do you have? You have a box. You put fiction and arguments in that box and start opening the Pandora box and start arguing. So moot courts are the most lucid, like a flow of water, window for the students. And that window, students, is giving you a real picture of what you are for. A real picture of a real life. That's real like courts. So a lot of questions now come. Why should a law student moot? Yes, you should moot. Lot of reasons. You can pick up any that suits your credential. I want to strengthen my writing and oral ability. I want to chisel my analytical ability. I want to build my skill and confidence. I want to look different from others. I want to enhance my personality, confidence, and speaking. I want to love to work in a team. I need to work in a team. I need to be a part of the team. And when I say team, everyone knows T for together, E for everyone, A for achieve, M for more. Together, everyone achieves more. That's team. And silently, I would also like to tell everyone, mooting enhances your CV. Yes, it does. So when you go to your employer and employer says, yes, my dear student, you are from Chanakya National Law School. Show me your CV. 1 moot court, 2 moot court, 3 moot courts. Wow, stupendous. That means apart from those bare acts, constitution, precedents, and books, you have learned something else. You have learned the art and craft of law, and very good, I will take you. And you go to an employer, what have you done? My CGPA is 9. Oh, brilliant. What else? Nothing else. Oh, nothing else? So how will you present your arguments? Sorry, sir, I will learn. Learn? Learn when you're coming to ask for a job? What did you do for 5 years? Only maintained your grades? Sorry, my dear friend. Learn and come back. I will hire you. So that's the difference. So now when I come back to what I'm really here for, some tips of international mooting and national mooting. When I say national mooting and international mooting, dear audience, you should not see the name of the moot. That is important, but not as a beginner. Don't go for very high aspiring moots, the brands. Brands are good, have some experience, ground level. So start with the national moot court, which involves your laws, your jurisdiction, your constitution, your high court, your Supreme Court. So national mooting, the source of law, is limited to a particular region or country. Whereas when you say international moots, the source of law is international and reference has to be made to the conventions. So you can't plead with Article 32 of the Indian Constitution and Article 226 for High Court jurisdiction of writs in an international moot. The setup is different, the context is different, the style to argue is different. So in a national moot court, you lay stress on your judicial precedents because it is an appellate jurisdiction problem. Your statutes, Indian Contract Act, Indian Environmental Act, Indian Penal Code, the rules that give you a defined character. Whereas when you say international mooting, apart from the conventions, the treaties, the charter, please remember the juristic opinion of the comments of the authors who are authorities in international law. For example, I say J.G. Stark, Oppenheim. These are the names that are known brierly. Those who have defined international law, given us the roots of international law, their opinion also matters. In your national mooting, the memorials, the written submissions, the arguments that you make, the plaints, as you call in a layman language, should be a blend of facts, laws, and application of facts. Whereas when you make a memorial from a compromise of an international moot court problem, your memorial should have more of law, and then you apply that law to facts. When you go for a national moot court, remember, you refer your bench as your lordship, your honor, but when you go for an international moot, you say, my excellency, your excellency. In a national moot court competition, the fictitious courts are appellate courts. In international mooting, the setup is not Supreme Court, High Court, district courts. You have an international setup. You have a fictitious international court of justice, and you refer to Rome statutes and the Vienna law of conventions in the form of treaties that bind your facts to the law that you present. National moot courts, generally you need 1 month, 2 months, 3 months preparation. For cracking the problem of an international moot court, you need more rigorous research, more time. Therefore, if you aspire to go for an international moot, at least 3 to 6 months preparation time is necessary. Now, coming to the other side, you unite. Yes, I'm using the right word. Unite written submissions and oral advocacy together. So remember 10 minutes back I said, I can't speak well. So what should I do? I can't moot. You can. Written submissions. You will be the best one to make a good written submission. Again, a question. I can speak flawless, but formatting, footnoting, I can't do that well. You can do. So we have a team. Thumbs up. Let's go. Unite. Do a moot with a blend of written submissions and oral advocacy together. I want to moot and I want to make things different. How do I produce a more effective memorial? Because you know, before you go to moot on the D-Day, I say D-Day because you remember when you are going to moot or you're going for your own wedding, you keep a lot of preparations pre-wedding, and when your wedding comes, we say, here comes the D-Day. Similarly, when you go in for a moot, your heart beats up, down, because tomorrow is my competition. There comes the D-Day. But before that D-Day, what really matters will be your submission of the moot memorial. And these things really count. How much knowledge you have of the problem and how much facts can you use. You have the knowledge, you know the facts. What is the amount and depth of your research? Simply knowing it, I know a lot of things. Will I be able to put that amount and depth in my research? I know how to argue. Will that argument have quality? So I'm going to use only those arguments in my written submissions or my memorial that have quality. Will I be able to analyze things? Can I have a good presentation? Can I use proper footnotes? So yes, when I'm making a memorial more effective, my knowledge, depth, quality, analysis, and the way I present, the eloquence of the drafting will matter. Now, I have to prepare for my oral arguments. Yes, look at the mooter. He is well dressed. He is confident. And he is preparing for the oral arguments, and today is his D-Day. So he comes before the court and he wants to introduce the problem. So I'll just give you a small illustration and you can feel how he presents himself before the court. He comes to the podium and says, "May I please the court?" And he takes a pause. But a pause that is very short, otherwise the judge will think he has forgotten his name. So he comes on the podium and says, "May I please the court? I am Counsel X, appearing on behalf of," because he is not the person who is coming himself to represent. If he is the accused, he will hire a counsel to represent himself. So I repeat, I am Counsel X, appearing on behalf of Mr. Y, the applicant in this case, in the matter of A versus B. So in these two lines, the counsel has introduced himself. He's introduced his client. He's also told that he's the applicant, the one who's filed the application. The case before the court is A versus B. And also, briefly, he tells the instant case before your excellencies, because it is an international moot court platform. The instant case before your excellencies concerns the illegal conviction of my client. Illegal, my excellencies, under the Regulation of Dissemination of Information Act, which conflicts his right to speech as a reporter. So you introduce yourself and the problem in a lucid manner using art and craft. So I'm not the only one who pleads. I have my teammate sitting with me and my researcher. So the counsel does not introduce the researcher, but with the illustration, I'm going to tell you how he introduces his teammate. And the illustration is, Your Excellencies, the instant case before the bench has been divided into two principal issues contained in the statement of facts. I shall be making submissions on issue number 1, and my co-counsel will be pleading on issue number 2. Take a pause. You must be able to communicate that there are 4 issues, 2 issues I'm going to take, 2 issues my co-counsel, or if there are 2 issues, 1 issue I'm going to take, 1 issue my co-counsel. And out of the total time allotted to us of 40 minutes, so please remind the judges that we are allotted 40 minutes of the time. We shall both take 19 minutes each of the court and reserve 2 minutes for rebuttal. If your excellencies may permit, I shall briefly state the facts. That's it. So you have introduced the problem, you have introduced the team, And then politely you say, much obliged, Your Excellencies. And if Your Excellencies permit, you can start with your argument. So this is the way you are prepared for your D-Day. Yes. Now, unfolding one more aspect, and that is a practical insight into training, into moot courts. So, some tips, some cautionary principles, some caveats, which all of us must be able to handle. When I say practical insight into mooting, and that is the topic that was given to me, practical aspects of international mooting. So when I say I'm very practical and I bring before you practical tips, practical insight makes you very pragmatic. Your proposition, your arguments are all handy, they're all readily available. You are feasibly available before the court, and the feasibility is whether this will happen or this will not happen. So you're tossing the coin from both the sides. You will learn to argue from both the sides. And that is what law is all about. Law is a tool which is used as an interpretation, and neither the respondent is wrong nor the appellant is wrong. Both appellant and respondent have their own arguments to present before the court. So practical insight makes you handy, functional, feasible, rational, workable, and more closer to reality. Some situations and challenges faced by mooters on the competition day. So here comes the competition day. You're all set to fight, argue, and bring your submissions before the bench of judges. So let us quickly overview some of the situations and challenges faced by us as mooters. Oh, this is a real picture, and I'm reminded of Amity International Moot Court Competition, and this is the Moot Court Hall where this mooter stands. So what is she trying to do? So many unknown variables come before her. She is well versed with the case, but can she predict what kind of questions are going to come to her? So there are a lot of unknown variables, and she's now going to do a mathematical calculation. And sometimes the issues and questions appear impromptu. They surface on the moment. Then what should I do? Should I be nervous? No. At times, the judge might ask me a question just to confuse me. Sometimes the question that the judge asks does not contain or does not relate to my moot problem. So, my dear audience, my dear friends, you have to be prepared to answer the unanswered things in the problem. And this is what mooting is all about. I can see the confidence in her eyes, and she's thinking, what kind of questions has their excellencies put before her? Oh, again, a picture from our moot court. The classroom, I remember, I trace my memory back to 2018. So we have two teams, the appellant and the respondent. One team is appearing before a bench of judges. The other team thinks, are we really confident? Are we really organized? Are we really prepared? But these are the questions that do come in our mind when we see our counter opponents pleading before the court. But the questions come to us till the time we don't start arguing. Once we start arguing, the ball reverses. We become confident. We are already organized. And yes, why not? We are prepared. So instead of are we confident, organized and prepared, the slide will take a turn and the slide would be we are confident, organized and prepared. And this is what mooting is all about. It makes you confident, organized and prepared to face the real world. Wow. Smiles on their faces. Probably they are reading the prayer. That is why all are standing and smiling and they have concluded their arguments. So when you read a prayer in a moot court, in the lights of the facts stated and arguments advanced, we may now plead the court to 1, 2, 3, 4. You ask the court for a relief. Based on the merits of the case, we may humbly pray before the bench of excellencies that our case should be decided on the merits of the facts and based on the principles of good conscience. The relief should be given to us. That's it. You're praying before the court. So you have to be precise and you have to communicate properly. So precision and good communication are your tools. Keep using them and you win a moot court. So now again, the lovely bench of judges. 4 sitting High Court judges you can see in the picture. Justice R.S. Enloji from Delhi High Court. Justice Mukhopadhyay ji, retired Supreme Court. Justice Jayant Nath, Delhi High Court. Justice Pratibha Singh, Delhi High Court. All sitting judges. And you appear before them. Amity and many other law schools have set a benchmark. We pick up the judges from the high courts and give practical training to the students to argue before them. So, traversing the stage of stuttering, mumbling, sir, sir, ma'am, 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 from that stage, we are now bringing you to the stage of being very effective. And when I say we, not we, that weak unquote quote is Moot Court competitions. So on your final day, please remember to assess the courtroom. You go to the courtroom, start doing investigations. Which side of the judges should I be seated? So there will be a placard written, you are respondent, arguing from respondent side, take that position. You are appellant, arguing from that side, take your position. So you don't have to do a lot of efforts. That placards are ready. And how loud should I be so that I'm pleasantly audible to the judges? So it's not that you see in the movies. You can't do that all the time. In an international moot court, you have to be very polite, very submissive. Then you think, will I be able to hand over the material to the judges through the court masters? How long will it take? You must assess the courtroom in the sense, you must try to arrange the proper material on the podium. So these practical advices really matter. They give you more confidence. And when your things are organized, when you know how loud you can be, when you know where you are sitting, when you know how to hand over the material, that stage of stuttering will automatically be coming to the stage of becoming more effective. Now, you are there in the moot court hall, you see 4 people sitting in front of you. In an international moot court, you have generally a bench of 5 judges. So when you see 5 of them just sitting before you and you are going to be grilled, you first have to present the opening line in the moot court and you announce your appearance. You make the judges believe that yes, you are there. Your Excellency, my name is Megha and I appear for prosecution in this matter. May I please the court? So when you say this, the judges are already pleased. They say, yes, agent, start. And you start. But please remember, you will have to tell the bench whether you are appearing on behalf of prosecution or respondent or applicant, and you every time have to please the court. May I please the court? Now, a confusion. How should I address the court? So when it's a national moot court and you have a bench of only men, you say your excellencies, and in a national moot court you say your lordship, so your honors. When you see a bench which has three ladies, you say, may I address the bench as your ladyship, your excellencies. But when you have two ladies, one gentleman, how do you say that? If the bench is composed of both the genders, then you are in a moot court. You can't ask them. Why not? You can ask them for sure. And if you say, if the bench allows the agent to call the bench as your lordship, so keep it same. Allow them to be called as your lordship, but when a lady asks you a question, then you will have to apply my ladyship. The counsel would now like to answer in the following words. So when a lady asks you a question separately, don't say your lordship. Please remember these etiquettes, courtroom etiquettes, they give you marks. So when you address the bench, keep it same for all the communications, but never use ma'am, sir in the moot courts. That is non-excusable, non-pardonable. All right? You are humans. To err is human, to forgive is divine. Mooters are human beings. Humans are not infallible. So, you are in a moot court. You know you have committed an error. You know that your error is going to give you negative marks. So is there any way to manage that chaos, that menace? Your team member looks at you with the eyes widely open that because of you now we are going to lose. But dear friends, you can be saved. How? If a judge asks you something and you don't know how to respond. So these are the common phrases that we use. I must submit my sincere apologies, Your Excellencies. I misread the facts. I would never dare to mislead the courts, My Excellencies. My Excellencies, please allow me to correct my submissions. My Excellencies, the council pleads ignorance. And you can be saved. They are not going to deduct your marks. But if you start arguing, then there can be a problem. Excellencies, you are asking me this question which does not relate to the facts of the case. Excellencies, how can you ask me a question which is something out of the purview of the moot problem? Excellencies, you don't know how to put a question before the council. No, a complete no. You must accept your faults, and even if you are not at fault, plead ignorance. That's the mantra. Now, coming towards the closure of my presentation, there are some tricks that you can use to persuade the judges on a point. Structure your argument well. Articulate your arguments well. Your presented points must be clear, relevant. So only clarity and relevance will not work. Why? Because you have to back your arguments with a valid legal proposition. And it should be verified by a valid source of law. So these are few tricks which you can use to persuade the judges. And please remember, art and craft. Now, let us sail in the cruise of few international law moots. I am an international law student. I know international trade law. I know international environment law. I know international criminal law. I know humanitarian laws. I know law of sea. I know international human rights. Then why are you waiting for? You are an international persona. So let us sail in few of the most renowned international law moots, and I am very happy and proudly say that I am the national administrator from India to represent India in Washington for the League of all the Indian national law schools and other universities who do a global round in India and then go for a final world global championship round. And he is Mr. Mark Lewis, the board of chair of ILSA, and he reminds us that Jessup is one of the world's largest moot court competition, and it gives you an experience which is rarest of the rare. Now we have some more Ivory League international moot court competitions. All these moots are there on the websites. We have the date of registration, how much time will it take for you to compete, what is the strategy, what is the theme, the proposition, whether a moot court has a global round or directly international rounds. But dear friends, generally all the international moot courts which I name and which are there in front of you, many of them, most of them will have a qualifying regional round in their own jurisdiction. And top 4 or top 2 or top teams then go from the qualifying matches to the global matches. So Stetson International Environment Competition, William Wismoot, Henry Dunant on International Humanitarian Law, Foreign Direct Investment International Arbitration Moot, Prize Media Law Moot Court Competition, Manfred Lech on the Air and Space Law, Leiden's Air Law Moot Court competitions are to name a few. And finally, when I rest my presentation, I extend a good luck to each one of you. And I'm sure after this session, you are going to create a transformation. And I'm again sure that you will all do great. So thank you so much for having listened to me. And I would like to thank Megha. Is my time up now? It's 7:45. If I can now take a few questions. If there are
Yes,
any
ma'am.
questions, I would be happy to take. Otherwise, from my side, the presentation is over.
Okay. Thank you, ma'am. If you can stop the screen share.
I'm just trying to do that. Yes, stop sharing.
Yes.
Yeah. So,
Yes.
Megha, should I read the questions or will you be able to read them for me?
Yes, ma'am. I'll read it for you.
Yeah.
Thank you so very much, ma'am, for addressing this very interesting and very timely subject. And I'll ask you questions.
Yeah.
Uh,
We can go ahead with the questions.
yes, yes, yes. Ma'am, the first question is that what do a person should do if the facts in the mood problem are incomplete or otherwise unsatisfactory?
Absolutely. This is one question which bothers many of us. For example, there is an organizing mood college that gives you a fact sheet wherein you feel the facts are incomplete or unsatisfactory. It is your right to call the organizers and ask help from them. Many a times I do get calls from a lot of students of National Moot Court Competition saying, ma'am, the facts are incomplete. And then I give them a very simple answer. Then read in between the lines. All right. So that is the very simple answer which I'll give to the person who has asked that question to me. Either you call the organizers because it can be an incomplete moot proposition. But if the organizers do not agree, because they will not agree, most of the organizers will say, no, the problem is complete. But if you are unsatisfactorily involved in that problem and you feel that I can't frame my arguments, then stretch it a little more. Use some other legislations that can be used as an aid for your moot problem. Don't restrict it only to Hindu Marriage Act. use adoption laws, use domestic violence, use other family laws, compare it with the personal laws, and then I think you will be able to get the answer to your unsatisfactory problem, or an answer that gives you that the problem is incomplete. But I do appreciate it has happened many a times that students, they read the problem properly, and many a times there are some typographical errors which change the complete meaning of the problem. So the organizers then release statements of clarifications. And it happens in all the moot court competitions, all the good colleges, they will definitely release clarifications. And in those clarifications, the problem should look like a complete problem. Yes. Next question, Megha.
Yes, thank you so much for answering this question, ma'am. My next question is how to deal with the time management during moots.
Yes, a very important question again. When we make a score sheet in a moot court competition, dear friends, the time management is a component that carries 10 marks. So as you incept the moot problem, you clear it to the bench and you clear it to your teammate by looking at him once like this, that we all, both of us are allotted 10 minutes each. But my dear friends, at times it happens that you are not allowed to speak, but your time tic-tac goes on. And the judges, they keep asking questions. And then you feel so claustrophobic that you're not able to speak. Time runs. But in all the good moot courts, again, and more so in international moots, because I keep judging international moots. In international moots, when a judge is asking questions, the timekeeper is told to keep an eye on the time, and then even they keep showing the judges that placard that only 5 minutes left. So the judge is also aware. Now let me allow the counsel to speak. So my dear friends, it is the time management that plays an important role. So because I said in my slides, there are a lot of variables that are coming impromptu. You can't predict. At times I have seen a mooter, if I trace back my memory, last year only, he was allotted 15 minutes. And the moment he starts speaking, one question, two questions, three, four, five, six, and he was not able to complete even one argument. But because he was able to respond to those questions, they were scored very well. And the time management is the essence to a moot court. So you will have to keep the time frame into account. But my dear students, if the judges are asking you questions and you are losing time, then wish you good luck. Because if you're able to respond to those questions, then time hardly matters. But the moment time is up, you will have to close your arguments. You can't say 1 minute, 2 minutes, let me complete, let me complete. No, a big no. If you are left with 20 seconds, so you will have to plead that, Excellencies, I'm just left with 20 seconds. Give me 1 minute more to wrap up. And if the Excellency says yes, then you can. Otherwise, you sit down and then the next argument to the next team. Okay, Megha, will it be able, will my friend who has asked that question, I think he or she would now be satisfied that yes, time management
Yes,
is important, but impromptuness is more important. Any other
yes,
question, Megha?
definitely. Yes, thank you so much for answering this one, ma'am. My next question is that, ma'am, during an international moot, on what resources should a student rely for citing judgments?
Very good question again. In international law, you know, how do we define international law? International law is law of nations. International law is different from national law, which talks about your jurisdiction. So you can't refer to the Indian Constitution, the preamble in an international law. The sources are important. And the sources in an international law are treaties, conventions, UN Charter, and the Bible, that is known as UDHR, that's Universal Declaration of Human Rights. That is the charter which gives an answer to a lot of questions. Plus, please remember, in an international moot, along with the moot proposition, they give you annexures. So they give you an annexure of the Roman Statute. They give you the annexure of the Vienna Convention. They give you the annexure of the Kyoto Protocol. They give you the annexure of the laws that are used as pari materia to a country which is there. For example, I say in an international moot court, the problem that I make represents two nations, India and Iraq. So there must be a treaty or an agreement before the International Court of Justice on which our mutual arguments are based. So we rely on those sources. Number two, as I said, jurists, authorities, those who have made names in the International Law Forum. Your textbooks also, dear students, can be used as secondary source. Last but not the least, in international law, equity matters. And you know what is equity? Equity is a source of law. When all these sources are silent, equity works. So you use the principle of equity and good conscience and then cite it with the help of foreign judgments, which are used as ratio decidendi, and then observations of the judgments that are used as obiter dicta. And these ratio decidendi and obiter dicta are the resources that can be cited for judgments in a moot court.
Yes. Thank you so much for answering this one also, ma'am. Just a last question that has been asked. How to handle the rebuttal portion of moot court competitions?
Yes. So rebuttals and surrebuttals are, you can say, like tails of the moot. So when you see a tail of an elephant going, you can predict, yes, the elephant might have gone. When you see a tail of a tiger going, you are a little scared. Oh, thank God, the tiger has passed away. So they are like tails. So when it comes to rebuttals and surrebuttals, you have to be very polite. I have myself seen in rebuttals, the mooters feel that they have a tool to now crisscross. But no, rebuttals are not for crisscross. Rebuttals are that you don't agree with one point which is posed before you from your opponent, and then you handle it politely by making the opponent realize that you are wrong. So that is like a lens of critical appreciation, and you must take rebuttals and rebuttals as tails of the moot, that the elephant has passed, now only tail is left, this too shall pass. So that's the answer to the question. Take it lightly, don't be aggressive, don't be very critical, but make the other realize that yes, we have caught you, you were wrong. That's it.
Thank you so much for this amazing session, ma'am. As you have been representing India for a long time in the renowned Jessup International Moot Court Competition and is currently serving as the National Administrator from India for Jessup, it was an honor for all of us to have guidance on international and national mooting from you. We are definitely honored and very happy, and
Thank you.
our
Thank you so
attendees are very
much.
happy.
Thank you so much, Megha. I am going to share my PPT with the organizers in case anyone wants the material of this PPT to keep it as a learning lesson, because I've tried to use my ideas to make this presentation. I've not copied any slide from anywhere. So if the students or the budding mooters or anybody who wants to recap and revisit what we did in this session, the PPT can be readily available. I'm going to share it with the organizers. All right. So one last thing before I want to conclude. Yes, formally I want to thank and express my gratitude to the organizers. I want to express my appreciativeness and acknowledgement to all the wonderful listeners and the people who are going to see this video later through live streaming. And I want to end this session by saying that memories are like pearls in a golden chain. Keep them safe till we meet again. So with this last poetic expression, I want to acknowledge on the fact that let us keep those pearls intact and keep them in our memories till we meet again. So thank you, Megha, Paki, and all the organizers of this wonderful forum. And we are blessed to be a part as mentors, and we will keep the flagship higher. Thank you.
Thank you so much, ma'am. Thank you so much, organizers, and thank you so much, attendees, for attending this session.
Okay, Megha, thank you so much. I'm now leaving.